Welcome back, future criminologists. In this video, I will be discussing the best evidence rule or original document rule. Best evidence rule or original document rule. Before the 2019 proposed amendment on the revised rules on evidence or Administrative Matter number 19-08-15, this rule is called Best Evidence Rule. May 1, 2020 onwards, the date of the effectivity of the administrative matter, the rule will now be called Original Document Rule. Best Evidence Rule or Original Document Rule is governed by Section 3 and 4 of Rule 130 of the Rules of Court. Best Evidence Rule states that when the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original document itself. As to the amendment, Original Document Rule states that when the subject of inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence shall be admissible other than the original document itself. The amendment does not limit the applicability of the rule into documents only. It now includes writing, recording, photograph, or other record. Thus, Best Evidence Rule or Original Document Rule requires that the original document must be presented in court. It is a rule of preference in that it excludes secondary evidence once the original is available. What do we mean by original document? An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. How about photograph? An original of photograph includes the negative or any print therefrom. If the data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. How about duplicate copies? Are they considered original? Yes, subject to condition. A duplicate is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. A duplicate is admissible to the same extent as an original. When is duplicate not admissible? 1. A genuine question is raised as to the authenticity of the original. For example, it was alleged that the so-called original is fake. Pag fake po ang original, fake din po yung duplicate. Second, in the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. When the original is to be presented. So, kailan ba dapat i-present ang original? First, if the subject of inquiry is the contents of the document. Second, when a testimony of a witness refers to the contents of a written document. Third, when the rule does not apply even if an existing and available original document is involved. First instance, when the original must be presented. If the subject of inquiry is the contents of the document. This means the cause of action or defense is based on what are contained in the document. That is, the terms and conditions, the entries, data or information written on the document. Halimbawa, si A may 10,000 utang kay B. Si A gumawa ng promissory note in favor of B. Ang promissory note na yun sinasabi niyang si A ay may utang kay B sa halagang 10,000 at babayaran ito ni A sa loob ng 10 araw. Pagkatapos ng 10 araw, hindi pa rin nagbabayad si A. Para makakolekta si B, kailangan niyang ipakita sa korte ang original na promissory note kasi dito manggagaling ang kanyang karapatan upang singilin si A. Second instance, when the original must be presented. When a testimony of a witness refers to the contents of a written document. For example, the complainant testified that based on the written agreement, the respondent should give him 10 sacks of rice every month. Since the complainant testimony refers to the contents of a written document, such document should be presented to the court. Third instance, when the original must be presented. When the rule does not apply even if an existing and available original document is involved. This third instance happens when, first, the contents of the documents were never disputed, such as when the question refers to the external facts about the document, such as whether it exists or not, whether it was executed, sent, delivered, or received. When the writing is merely a collateral fact, as when a witness refers to a writing of a conversation which he heard and then jotted down, or when the writing is used merely as a point of reference. When the contents were admitted. The writing is treated as an object. If the writing is treated as an object, it will be treated as object evidence. In object evidence, the best evidence rule or the original document rule does not apply. Second, when there was failure to deny specifically under oath the due execution and genuineness of the document. Third, waiver by the adverse party. The exceptions to the best evidence rule or the original document rule is secondary evidence. I will discuss secondary evidence in our next videos. Thank you for watching. If you like this video, please share, like, and subscribe.